Dear learners, I welcome you all to this lecture on understanding human rights in India. We have been discussing about the preamble of the Indian Constitution, India's international obligations. Then we also discussed some other aspects of fundamental rights of the Indian Constitution, the constitutional framework of human rights in India. Now we are going to discuss in this lecture the fundamental rights or the provisions of fundamental rights that are there in the Constitution of India. First of all, let's see that Article 13, it says laws inconsistent with or in derogation of the fundamental rights. What will happen? All laws enforced in the territory of India immediately before the commencement of this constitution, that is 26 January 1950. Insofar as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void. So if they are in conflict with the fundamental rights, all the old laws, they will be declared as void. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall to the extent of the contravention be void. Again, fundamental rights, they cannot be taken away. Now, what are the fundamental rights that we are discussing? The qualifying statement we have already seen, that even the old laws or even the new law to do away with the fundamental right, they cannot be acceptable. Now we have Article 14. Article 14 of this is dealing with a right to equality. So it is first of all, Article 14 is saying there will be equality before law. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. So a country that has already witnessed gross inequalities in the past for centuries. So that way, this law which is ensuring legal equality, equal protection of law and the equality before the law, that becomes very, very important. Article 15, prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. So we have Article 15, that is prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. Discrimination on these grounds have been there in the country. So that's why, these challenges have been faced by the people in this country. So that is why the constitution is making it, mandatory that there should not be any kind of discrimination. And how it is being elaborated? The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth or any of them. The word only that has been mentioned here, that the state shall not discriminate against any citizen on grounds only. This only is very important. Only of religion, race, caste, sex, place of birth or any of them. So it means if the positive discrimination is there, for example, it should not be only on the ground of religion, race, caste, sex, place of birth, etc. But other things are to be taken into consideration. No citizen shall, on grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, and places of public entertainment. You'll find that certain people were declared as untouchable, certain people, even during the time of British colonialism, you'll find there were certain places that were restricted for Indians. They were, Indians were prohibited to go to those places. So this was the reason that, this right is also important. Access to shops, public restaurants, hotels, and places of public entertainment. Or the use of wells, tanks, bathing ghats, roads, and places of public resort maintained by wholly or partly out of state funds or dedicated to the use of general public. So again, you will find that the father of the Indian Constitution, Dr. Ambedkar, his life was dedicated to fight against discrimination. So that is why it is being reflected in this clause of the Constitution that the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public, that there should not be any kind of discrimination on grounds of religion, caste, creed, sex, place of birth. For example, you will find in before the commencement of the constitution, the people from the so-called untouchable caste, former untouchables, very derogatory, of course. These people not allowed to draw water from the wells and the tanks that were there where the people or people from the general caste or the upper caste used to take water. And that's why, this was the reality in the country. So the constitution is abolishing all these things. Nothing in this article shall prevent the state from making any special provision for women and children, of course. Article 16, equality of opportunity in matters of public employment. That is again important. Public employment, why it is important? Because the state apparatus, if you are seeing, you know, if the proper representation of all the communities or what is called the social composition is not reflected in the public employment or in the state apparatus, then that state cannot do justice with all the people. So therefore, what has been ensured through the constitution, that equality of opportunity in matters of public employment. There shall be equality of opportunity for all citizens in the matters relating to employment or appointment to any office under the state. No citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them, be ineligible for or discriminated against in respect of any employment or office under the state. Then nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government of or any local or other authority within a state or union territory any requirement as to residence within the state or union territory prior to such employment or appointment. This is exception that is being made. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward classes of citizens, which in the opinion of the state is not adequately represented in the services under the state. This is important. So the OBC reservation, for example, in our country, so that will not be the violation of right to equality principle. 4A, nothing in this article shall prevent the state from making any provision for reservation in matters of promotion with consequential seniority to any class or classes of post in the services under the state in favor of the scheduled castes and scheduled tribes, which in the opinion of the state are not adequately represented in the services under the state. So that is also justifying reservation in promotion or a special consideration for reservation for promotion so far as the scheduled castes and scheduled tribes are concerned. 4B. Nothing in this article shall prevent the state from considering any unfilled vacancies of a year which are reserved for being filled up in that year in accordance with any provision for reservation made under Clause 4 or Clause 4A as a separate class of vacancies to be filled up in any succeeding year or years, and such classes of vacancy shall not be considered together with the vacancies of the year in which they are being filled up for determining the shielding of 50% reservation on total number of vacancies that year. Again important for, this is, for example, if the vacancies are advertised, they are not filled up, then and for the new vacancies that are coming, so that will not be counted in this. So that is again important to ensure that some kind of mischief can be played by the people, those who are dominant, and the non-dominant caste can suffer. So that is why this provision has been included in the Constitution of India, and for which, of course, the Constitution should be, the people should be appreciated. The amendments that have been brought, that should be appreciated. Nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with the affairs of any religious or denominational institution or any other or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. Of course, the exception are there, that is needed. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any economically weaker section of citizens other than the classes mentioned in the Clause 4, in addition to the existing reservation and subject to a maximum of 10% of the post in in each category. So, after maximum of 10%, after that there is full stop that you should delete. It is of the post in each category. So it means that, this is dealing with the economic reservation. So the reservation for the economically weaker section of society, EWS, that have been made through this particular exception. Article 17, dealing with abolition of untouchability. It has been a problem in our country. You should read Annihilation of Caste by the father of the Indian Constitution, Dr. B.R. Ambedkar. And, the untouchability was something that was a blot on our, country, and it has been abolished by the Constitution of India. So, abolition of, after abolition of untouchability, the practice of untouchability is a punishable crime now. Abolition of titles. No title, not being a military or academic distinction, shall be conferred by the state. No citizen of India shall accept any title from any foreign state. No person holding any office of profit or trust under the state shall, without the consent of the president, accept any present, emolument, or office of any kind from or under any foreign state. So you see that from 14 to 18 how the Constitution of India is trying to promote equality, abolishing untouchability, abolishing titles, and trying to develop the spirit of equality in the country. At the same time, keeping in view the different challenges that the society is facing and the inequalities that the India is suffering from, right from the very beginning, historical disadvantages of the various communities. It has also made many exceptions. So the reservation for scheduled caste, scheduled tribe, OBC, women, children, and of course, a special treatment for them. And then, finally, the EWS, economically weaker sections of the society, they can be especially favored. So that is something you can see. India is a very, the Constitution is a very progressive kind of document which is trying to address the challenges that the country is facing from time to time. Now, right to freedom. Article 19. Protection of certain rights regarding freedom of speech, etc. All citizens shall have the right. Now you see, all citizens shall have the right to freedom of speech and expression. First of all, you will find this is one of the most important civil rights. It also has a political dimension. So it is one of the most important civil and political rights which has been demanded right from the very beginning. If you see the Western liberal revolutions. So the civil and political rights, which includes right to freedom of speech and expression, which is must for the complete personality development of an individual or the potential of an individual. To assemble peaceably and without arms, to form association or unions or cooperative societies, to move freely throughout the territory of India. To move freely throughout the territory of India, it has been repeated. You should note, to reside and settle in any part of the territory of India. So these are the freedom that have been. Freedom of occupation is also there, that is missing. So you can mention, or we will make correction. So Article 20, protection in respect of conviction for offences. No person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act, charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. So a person will be punished according to the law that was existing when the person committed a crime. So, retrospect and prospects kind of legislation will not be there for punishing the person who has committed a crime at a particular point of time. No person shall be prosecuted and punished for the same offence more than once. So this is again the law of double jeopardy. So no person shall be prosecuted and punished for the same offence more than once. No person accused of any offence shall be compelled to be a witness against himself. Very, very important. So it means that sometimes what happens that the people in custody who are very helpless because of the torture or third degree or custodial torture, they are giving their statement. So, what the Constitution has ensured, no person accused of any offense shall be compelled to be a witness against himself. Article 21, protection of life and personal liberty. Article 21A, right to education. You see, what is there? Protection of life and personal liberty. You see the progressive interpretation of the provisions of the Constitution. What has been added in the Constitution of India are not there originally in the Constitution of India. So Article 21A, right to education, that has been added in right to life and personal liberty. If you see many judgments, you will also find what is the best part, that right to clean environment has been also interpreted as part and parcel of right to life. This is expanding the horizon of right to life by the Supreme Court of India. So many landmark judgments you will find that have been delivered by the Supreme Court of India, in which the horizon or the scope of right to life and personal liberty has been expanded. Article 22, protection against arrest and detention in certain cases. No person who is arrested shall be detained in custody without being informed as soon as may be of the ground for such arrest, nor shall be denied the right to consult and to be defended by a legal practitioner of his choice. Fundamental right, you see. Every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of a magistrate. So, that is again habeas corpus. Within 24 hours, a person arrested must be produced before the nearest magistrate. Nothing in clause 1 and 2 shall apply to any person who for the time being is an enemy, alien, to any person who is arrested or detained under any law providing for preventive detention. Certain exceptions are there. The preventive detention laws are also there that in our country, for example, UAPA, and they have different provisions. So if the people are arrested under preventive detention, so the provisions will be different. No law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months unless an advisory board, this is again exceptions that have been given, of course, dealing with the preventive detention, etc. So these are again exception clauses that you can read from here. After that, we are going to deal with right against exploitation. Article 23, that is dealing with right against exploitation, and that is prohibition of traffic in human beings and forced labor. Traffic in human beings and beggar and other similar forms of forced labor, that is called begar in our country. So traffic in human beings and begar and other similar form of forced labor are prohibited, and any contravention of these provisions shall be an offense punishable in accordance with law. So traffic in human beings and beggar and other similar forms of social forced labor are prohibited, and any contravention of this provision shall be an offense punishable in accordance with law. Nothing in this article shall prevent the state from imposing compulsory service for public purposes, and in imposing such services, the state shall not make any discrimination on grounds only of religion, race, caste, or class, or any of them. So again, this is important. Then you have Article 24, prohibition of employment of children in factories, etc. So, the children will not be, the child below the age of 14 years will not be employed in the hazardous industries. Then you have many subsequent laws have been made, that is abolition of child labor. You will also find abolition of bonded labor. So bonded labor, that is begar labor, and also the child labor, that is something that have been taken care of through later legislation. So it is not only constitutional provision, but other legislations are also important from this point of view. Now, right to freedom of religion. As we mentioned that India is a multi-religious country, It's a multilingual, multi-religious, and its exciting diversity is something that must be appreciated, where more than 1,500 languages and dialects are spoken. You see, our schedule itself is recognizing or mentioning 22 scheduled languages. So you can understand the linguistic and the religious diversity, cultural diversity in the country. And keeping in view, you see what are the provisions that have been incorporated in the Constitution. They are dealing with right to freedom of religion. Article 25, freedom of conscience and free profession, practice, and propagation of religion. So, subject to public order, it is not absolute right. Again, remember, subject to public order, morality, and health, and to other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law, regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice. So that regulation can be there by the state, because there are many exceptions that are to be taken into account while claiming these rights or enjoying or realizing these rights. Providing for social welfare and reform, or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. For example, you will find that earlier, before the commencement of the constitution, the people from the so-called former untouchable caste, they were not allowed to enter into temple. So that is why it has been especially mentioned that providing for social welfare and reform, or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Article 26, freedom to manage religious affairs. To establish and maintain institutions for religious and charitable purposes, that is a fundamental right. To manage its own affairs in matters of religion. To own and acquire movable and immovable property, and to administer such property in accordance with law. Article 27, freedom as to payment of taxes for promotion of any particular religion. So, no citizen can be compelled to pay tax for promotion of any particular religion. Article 28, freedom as to attendance at religious instruction or religious worship in certain educational institutions. So, what is there? That no religious instruction shall be provided in any educational institution wholly maintained out of state funds. So, this cannot be there, that a particular religion cannot be promoted in any school or college or university or institution that are maintained by the state. Nothing in clause 1 shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution. This is again exception clause. No person attending any educational institution recognized by the state or receiving aid out of state funds shall be required to take part in any religious instruction that may be imparted in such institution, or to attend any religious worship that may be conducted in such institution or in any premises attached thereto, unless such person, or if such person is a minor, his guardian has given his consent thereto. You see that what kind of mutual respect, religious tolerance that is being emphasized through this particular clause. And now we are coming to cultural and educational rights. Article 29, protection of interest of minorities. There is one, you see the heading, the marginal heading of this article is cultural and educational rights. And what is the subheading? You see, protection of interest of minorities. So that contradiction you will find, that any section of the citizens residing in the territory of India or any part thereof having a distinct language, a script or culture of its own shall have the right to conserve the same. So any section of citizens, it means protection of interest of minorities, why it has been, the title is there, but it is there for any section of citizens. So all the people collectively, even for example, all the collectivities, whether they are minority or majority, from this clause we can understand that any section of the citizens residing in the territory of India or any part thereof having a distinct language, a script or culture of its own shall have the right to conserve the same. That is there. So, it is the conservation of language, script, and culture. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language, or any of them. So again, non-discrimination principle is important here, that has been highlighted. Article 30, right of minorities to establish and administer educational institutions. You see clause 1, Article 30, clause 1. All minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. So first of all, the linguistic and religious minorities. Keep it in mind, whether based on religion or language. So, for the purpose of this article, two kinds of minorities are being recognized by the Constitution of India, that is religious minority or the linguistic minority. So, the religious or linguistic minority shall have the right to establish and administer educational institution of their choice. Why? Because you see that the minorities or any section of citizen has been given the right to conserve its language, script, or culture. So it seems, that what is the intention of the framers of the Indian Constitution? They wanted to create a culturally autonomous, spaces, or autonomous cultural spaces rather. I should say autonomous cultural spaces for the minorities, linguistic and religious minorities, because you see it is quite natural all over the world, and it is a universal phenomenon that minorities, they want to preserve their identity. And when they want to preserve their identity, so that is why they must have autonomous cultural spaces. So that is why in that culture, these educational institutions can be assumed as autonomous cultural spaces for linguistic and religious minorities. In making any law, you see the exception, any law for providing the compulsory acquisition of any property of an educational institution established, administered by a minority referred to in clause 1, the state shall ensure that the amount fixed by or determined under such law for the acquisition of such property is such as would not restrict or abrogate the right granted under that clause. Then you will find Article 30, clause 2. The state shall not, in granting aid to educational institution, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. So not only minorities, linguistic and religious minorities have a right to establish and administer educational institution of their choice, but again, right to receive aid from the state is also their right. So the state shall not, in granting aid to educational institution, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. So, this point is also important, that the state will not discriminate against such institution because they are being maintained by the minority. So that is why no aid will be given to them. So that is why you have many aided minority institutions in the country, because it is already mentioned in the Constitution of India. And you have to see the prenatal history of Article 2930, how it was drafted, and what was the spirit, what was the intention of the framers of the Constitution while, incorporating these two clauses under Article 30. So that is very important to understand. Then Article 31, of course, that was right to property, which has been omitted or abolished. Then we have right to constitutional remedies. Article 32. I have already told you that Dr. Ambedkar said or observed that right to constitutional remedies, they are basically heart and soul of the Indian Constitution. Let's see what are the remedies that are given for, when the human rights are encroached upon or the fundamental rights are encroached upon. Number 1, the right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is granted. The Supreme Court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this part. Without prejudice to the powers conferred on the Supreme Court by Clause 1 and 2, Parliament may, by law, empower any other court to exercise within the local limits of its jurisdiction all or any of the powers exercisable by the Supreme Court under Clause 2. The right granted by this article shall not be suspended except as otherwise provided for by this Constitution. Then you have to see Article 32A, constitutional validity of state laws not to be considered in proceedings under Article 32, omitted by the Constitution 43rd Amendment Act 1977. So you see that with this we come to conclude the fundamental rights that are there in the Constitution of India. And in our next class, we will be continue, discussing other rights, for example, from the directive principle of state policy and other provisions of the Constitution relating to human rights. Thank you very much. We are meeting in the next lecture to continue our discussion on constitutional provision and human rights in India. Thank you very much.